Where do you sign in?
No, not yet.
All right, everybody, thank you so much for coming out tonight. We have a very full house, so please squeeze in. Make sure your seats are available next to you. We are out of handouts, but I'm going to be printing more. So when I come back in the room in just a few moments, raise your hand if you don't have one, and I'll be dispersing it then. Tonight's topic, we're very excited, is evictions. We have a specialist, Jeremy Shorts, and so I'll turn the time over to him.
Thank you. A couple of things first. I have we do a monthly newsletter that talks about landlord issues and different problems and questions that we get in our law firm and with different clients that call in. If you would like to get a copy of that, it's just emailed out. We don't do more than once, twice a month max. We sent one out today for this presentation. But if you'd like to subscribe to that, you can do it on our website, or I'll pass this iPad around. If it looks like I share an iPad with a 4-year-old, I do. So you can, if it were mine, I wouldn't complain too much if you stole it. But think of the children. Don't blow it. So I'll just pass that. We'll start. Clear it out of the back and then just bring it back up and you'll make it around. So I'm with Utah Eviction Law. I started at Utah Eviction Law about 2009. I've been an attorney for just about 10 years now. So we have 2 attorneys in our firm, some staff to help out with everything, and all we pretty much do is focus on eviction work. And so nobody ever calls us to tell us how great their day is going. It's always all the problems. And so we always have a lot of good stories and some things to talk about. Can you guys hear me in the back? Am I talking loud enough? No? Okay. I'll be a little louder then. So whenever I start out talking about the training that we do, we always talk about there's a lot of free legal advice and a lot of war stories, obviously, when you have evictions. The first piece of legal advice that I want you to know: do not rent to Rosalind Fiedler. She has, and I've had to update this every now and then, it used to be 18 prior evictions, and I checked, she's up to 19 prior evictions. So whatever you do, first and foremost, the best thing you can do to avoid an eviction is know who you're renting to. Do thorough background checks, because somebody will rent to Rosalind Fiedler again. The last one that we had, a guy called in and said, my tenant just moved in, hasn't paid the first month's rent, and as soon as they say that, I said, well, let me do a background check for you, because you didn't, by renting to somebody that walks into that situation. That doesn't normally happen if you do some background checks. And so I said, what's her name? And he said, oh, it's Rosalind. I can't remember her last name, and you don't hear Rosalind all that often. And so I told him, I said, don't say Fiedler. And he said, how did you know? I said, well, let's see how many evictions she has now. So we've evicted her multiple times. So that's step number 1, don't rent to Rosalind Fiedler. If you do an eviction wrong, I know from experience that's a little bit how it feels. You want to make sure that you do this right. We have a lot of clients that just think that you can change the locks, turn off utilities, decide that because they're late on the rent, you want to repaint all the exterior doors for a few days, and so you need to take them off. Don't do that. That will definitely put you on the defensive and put you in a horrible situation. You definitely don't want to do that. The goals during any eviction, there's 2 of them. Number 1, possession of the property. You want to get that property back, and most of the time that is the first and foremost goal, is to get them out so you can get a new tenant in. And second is damages. And you really want to keep those separate. Just because somebody leaves the property, a lot of times tenants think, well, you gave me a 3-day pay or quit, and I quit, I left, and so I don't owe anything. Well, no, thank you, you left so we don't have to evict you, but now there's still the damages side of how we're going to handle the financials. And so keep those issues separate in your mind, but the nice thing is with an eviction case, you can combine those. We handle both of them in the same case. You can file for eviction, ask the judge for an eviction, an order of restitution is what it's called, an eviction order, to have the sheriff evict them. But we also work to get a money judgment that we can work on collecting on. Before you file an eviction, in really just about any case, there's always 2 questions that you want to ask. Number 1, do we have a good claim? Are we going to win? Of course, don't file a lawsuit if you're going to lose. And then number 2, are we going to be able to collect on the judgment? And a lot of times that's a balancing act, right? You want to say yes to both of those. You don't want to win a case and then find out that you're not going to be able to collect anything. You really want to say yes to both of those at the same time. But Evictions are different though. Even if you're never going to be able to collect, so they don't have any money, they just filed bankruptcy or they're going to file bankruptcy, even if they're judgment proof where you're not going to be able to collect, you still would want to consider an eviction because you need to stop the bleeding, regain control and possession of your property, and get them out so that you can start the process over with a new tenant. So even if we're never going to be able to collect, that's one unique thing about evictions, is they have possession of the property and we need that. So we need to go through that eviction process to get them out. A couple of general pointers about evictions and collection cases. An eviction is where the tenant has violated an eviction notice and they remain in the property. And a collection is where the tenant moves out and they've left a balance. And so just keep those two in mind. If you can pick, and if you're interested in collecting, definitely please treat that as an eviction case. Because an eviction is really both. It's got the eviction aspect plus the collection aspect. But the collection side, if you just do the collection case, they can be a little bit more difficult. With an eviction, they're faster. On average, we're about 2 to 3 weeks to get the tenant out of the property. Now, collecting on the judgment afterward can take some time. But that's lightning speed compared to other evictions. When I first graduated law school, I was in a law firm, and it was not uncommon for lawsuits to last for a year or more. And evictions are much faster. And so if you let them leave, and then you decide I want to collect, we're not on that fast track. It's treated as a collection case versus an eviction. Sorry, let me go back. The second thing is the amount of the judgment. In an eviction, you're going to get a much higher judgment because you're automatic. By statute, the statute says that the judge shall award attorney's fees and treble damages. And you can still get attorney's fees in a collections case as long as your lease says it. But if it's an eviction, you get attorney's fees under the lease and under the statute. And you also get treble damages or triple certain charges. So that can really help to get you a higher judgment. And then the last thing is service. If you wait until they leave and then decide how I'm going to try to collect, how many of your tenants that owe a balance, owe rent, damaged the property and left, say, hey, I just wanted to give you a good forwarding address so that you can sue the pants off of me. It doesn't happen. But while they're in the property, you know where they are. It's much easier for me to send my process server out there to serve them with the court papers where they're still in the property, we still know where they are. Once they leave, we're starting all over to try to find them, and sometimes that can take a long time to locate them. So, evictions, the basics of an eviction, under Utah law, there are only 2 ways to legally get somebody out. And you'll notice there's more than 2 ways to get somebody out of the property, but there are 2 legal ways to get somebody out of the property. Number 1, they voluntarily leave. And if that's a variety of situations, including a cash for keys. So if you're out this weekend, I'll forgive rent, I'll give you $100. Those are all options as well. If they don't leave voluntarily, you've got to go through the court process. And Utah law is very specific that they either need to leave voluntarily by abandoning the property, a cash for keys, or you've got to go through that court process. Now, this is how I classify my evictions. I've put them into 2 groups, paper evictions and opinion evictions. And what I want you to do is if you end up where you think, well, I'm going to have to take this one to court, this might end up, I might need an attorney on this one. What I want you to do is help build a good case. I don't ever want to file an eviction where we're going to lose. So help me build a good case. And so what I want you to do is focus on what the judge is going to rely on to make his decision. Is he going to look at papers, or is he going to rely on opinions? With a paper eviction, what I get to tell the judge is, Your Honor, it really doesn't matter what everybody is saying and what the tenant's complaining about. Look at these papers. These papers show that we're entitled to an eviction. They don't require any opinions or major testimony for the case. It really is just look at these papers. With an opinion eviction, it's the exact opposite. What I'm saying is, Your Honor, I'd really like you to believe my client more than the tenant. And when we have to go that route, if we don't have any other options, we still build a good, strong case to where usually we're successful. I did have one case, though, where at the end of the hearing, the judge told my client, I hear what you're saying, I'm just telling you I don't believe you. And to be blunt, when we got into court, the opinions were different than what were expressed to me, and I think the judge got it right. I really do. But it's really rare that we walk out of court without an eviction order. And so I want to build that up to increase our chances as much as possible so that we're successful. The types of paper evictions are typically the 3-day pay or quit and the no-cause lease termination. Because with those, what rent's owed, what's been paid, a lot of that's documented evidence of what has been paid. Check stubs, receipts, that type of thing. Or the no-cause lease termination. You can give the no-cause lease termination to the best tenant in the world. I doubt this is ever going to happen, but if you had a tenant that gave you a Ferrari for Christmas, you could still give him a 30-day notice if he's on a month-to-month basis, and we'll talk about it, but you can still give him a no-cause notice, and he's going to come in and say, Your Honor, I gave him a Ferrari, and we're going to say, Your Honor, it doesn't matter all the opinions that are going on, look at the papers. Now, of course, that would never happen. If our tenants gave us a Ferrari, we'd be happy. With the opinion eviction, it's basically everything else. And so if you can treat this as a paper eviction, do that. It's much better to do it that way. I had a client call me a while ago now and said, we went over, it's a duplex, we live in one side, the tenants live in the other. They were late on the rent. We started talking to him about it. He went nuts and punched me in the face, and the police were called, and then he tried to tell him that I attacked him. And I said, okay, well, is he on a month-to-month basis? Yeah, he is, but he assaulted me. Okay, you've got a paper eviction that we can do, or an opinion eviction that we can do. Which one would you like? And I just said, look, I really think let's be patient with this. Let's treat this as a paper eviction. Let's just give him a no-cause lease termination. We need to be out at the end of next month. Then we don't have to argue about it. We don't have to worry about what who's the judge is going to believe. And that was the best way to go in that case. One thing real quick, a good landlord will help to turn an opinion eviction into a paper eviction. So do all these things. Take pictures, get witness statements, help to document things. Create a journal that talks about the different entries of so-and-so did this today, and start creating a documented file that can help to build up that case and help to move it away from just a sheer opinion eviction and turn it a little bit more into a paper eviction. It's a stronger case when you get into court. So evictions, every single eviction under Utah law has to follow these 3 steps. Number 1 is serve an eviction notice. And notice, I put plural on purpose. Serve as many notices as that apply to your circumstances. If you look at the UAA, use some good forms as well. The UAA's forms are great. There's a variety of eviction notices that you can serve. And there's a lot of times where somebody will call and say, their friend moved in and now they've gotten in a fight and the neighbors are complaining. Okay, that's one situation, but I would look at giving an eviction notice for lease violations. Do all the different ones that you can. We had a case a while ago where I knew it was going to be a hard one. And so I told the landlord, serve these 5 different eviction notices. And I'm glad that they did, because the tenant fought it. We got into court, and before we get in front of the judge, I always sit down with the tenants and say, is there anything we can work out? How quickly can you move out of the property? And she said, I'm not moving at all. And I said, okay, that's fine. So I'm going to tell you what I'm going to tell the judge. And I had all 5 eviction notices. And I pulled one of them out, laid it on the table, and I said, you haven't paid your rent. Now I know what you're going to say. I read what you filed with the court. You were justified in not paying your rent because of this, this, and this. Legally, I don't think that's sufficient. But let's say that you win. You damaged the property. Now I know what you're going to say. It wasn't you, it was your friend. Legally, you're still responsible for the unit. But let's say that you win. You've assigned or sublet the property. Now I know what and I did that for all 5 notices. And when we were done, I had 5 notices fanned out on the table. And I told her, I said, for you to win, you have to beat me on every single one of these. For me to win, I just need 1. So, back to my first question, when do you want to move out? I'll give you some extra time, because if we go in front of the judge, I go with the fastest that we can, which is typically 3 days. So what do you want to do? And she settled, and it worked out great. And the only reason she settled is because the landlord served multiple eviction notices. So definitely do that. And we'll go through the notices in a few minutes. Number 2, once those notices have expired, file the eviction with the court. And number 3 is an eviction hearing. And typically you only have to go through that step if the tenant disputes the eviction. So if they don't fight it, then we typically don't have to do that. It's all paperwork, and luckily nowadays it's all on an e-filing system. So as soon as the judge approves anything, we get an instant email. We don't have to wait for mail or phone calls or anything. So that really helps to speed things up. And like I said, we're about 2 to 3 weeks to go through that process. And don't change the locks unless you've gone through all of these steps. Now at any point, there's still those two options, the option of abandonment where they leave voluntarily. That's completely fine throughout this process. But they either need to leave voluntarily or you've got to go through those 3 steps to get them out. So summary of eviction notices. Here are all the main eviction notices under Utah law. And you can, anytime you have, even if it's just one single event that happened in an hour, you can find 4 or 5 eviction notices sometimes that would apply, and you should serve all 5 of those notices, whichever ones apply. So quick pop quiz. How many days for each notice? This is where you should be, anytime a landlord starts complaining about Utah law, I tell them to move to California or move to New York, where a simple slam dunk eviction takes 2 to 3 months easy for a slam dunk. So I see a 3, and most of them are 3 days. So all of those are 3-day notices. If they're a tenant at will, which we'll talk about, it's a 5-day notice. And if it's a no-cause lease termination, it's 15 days. And so the question is, what if your lease says a longer time? What if your lease says, instead of a 3-day pay or quit, it's a 10-day default period or a 10-day pay or quit? If your lease says a longer time, go with your lease. What if your lease says a shorter time? You've got 24 hours to pay or quit. You go with the law. I wouldn't shorten these, but if your lease extends those, and for example, a commercial lease, it's very common to extend these on a commercial lease. Depending on the type of the breach, there's a lot of times where they'll say, okay, if it's payment of rent, that's 3 days, that's 5 days, 7 days. If it's another breach of the contract, it's 30 days. And you can do that, that's completely fine. But under Utah law, the large majority of them are 3 days, and if you extend that by contract, then you should stick with that longer time frame.
So,
What?
so if you're going to serve a no-cause lease termination, should you go ahead, and some of these other 3-day things could apply, should you serve the 3-day things as well as your lease termination?
So the question is if you've got some that are 3 days and you've got a lease termination, should you do both of them? And I would definitely do that. There might be some circumstances where you wouldn't, but generally I would, because there's several cases where we've done the 3-day notices, they didn't comply, we filed the case, and then they dispute it, and by the time we get into a hearing, it's February 4th, and I walk in with an eviction notice that says they should have been out 4 days ago. That helps to, just from a practical argument, to let the judge know, even if there's a problem with the 3-day notices, they were given a 15 or 30-day notice to terminate the lease, and they still haven't left.
Which notice do you file for damage to property?
That's the waste notice, and we'll go through, I'm going to go through each one of these, but waste is, that legally, that's damage to property, is waste. Have a good story and some good pictures on that. So the 3-day pay or quit, this is the most commonly used notice, and it has to be a pay or quit. There's sometimes, every now and then, we get the paper saying, now my tenants won't leave, I need you to file the eviction. Here it is, and they send everything in. And they don't want to deal with these tenants, and so they've got their pen and they scratch out or, and they write and. I want you to pay and quit. They've just invalidated their eviction notice and they get to start the 3 days over. I wouldn't file that one because I don't want to take the loser case to court. So you definitely, Utah law is clear, it has to be a pay or quit. You have to give them that option. And they have to pay the entire balance. If it's a partial payment, we'll talk about that next. If it's a partial payment, they're not complying with the notice, and it gives you some options as the landlord. And your lease cannot waive their right to pay. You have to give them that right to pay or quit. And this is a paper eviction. Remember, anytime you're having a problem with the tenant, I would like you to look at the 2 paper evictions first, the 3-day pay or quit, and then the no-cause notice. Here's a common question that we get. What happens if you don't care about the money, you just want them out? We get calls every now and then where it's like, I'm so sick of these guys. I don't want any money from them. I just want them out. The answer is you still need to give them the pay or quit. And as soon as, and they'll say, well, they're not going to pay. Great. Then that lets us evict them. But for us to file a case with the court, I have to have an eviction notice that's been given to them that they haven't complied with. So we need to at least give them that option. And if they don't, then we can move forward with the eviction.
How do you document what you've given them?
The UAA forms are the same. We have forms on our website. Down at the bottom, it's got a certificate of service that you fill out showing how it was served. And we'll talk about service in a few minutes, of the different options and how you can help document that. So here's a question for you. What can the 3-day pay or quit include? Obviously, it can include rent. The statute says rent and other amounts due. So what about security deposits? If they don't pay a security deposit, can you evict them? Damage to the property, late fees, unpaid rents. For me, what I would do is make sure that you're using a good lease, and the UAA lease is excellent on this. Use your lease to define what you can give, what they owe, and what you can give an eviction notice for. We had a case a little while ago where the landlord called and said they've paid all the rent, but we broke the deposit up over 2 months, and they missed that second payment, and she's refusing to pay it. And she said, I can't evict her because it's not rent. And so I gave my client the speech that I think legally you're fine, but I know judges are concerned about issuing an eviction where they're current on the rent, but they owe other things. And she decided she'd roll the dice and see what happened, and we got it in front of the judge. And right off the bat, the tenant knew which buttons to push. Your Honor, I'm current on my rent. And so then he turns to me, well, Mr. Schwartz, why are we here? She's current on the rent. I said, Your Honor, she is, but there are other amounts due. Well, like what? A security deposit? I'm not going to throw somebody out because of a security deposit. Flat out said that. I said, Your Honor, if you'll read the statute, I think it's clear that we can do this. And I think just to shut me up, he pulled out a statute book, pulled it out, and he was a little annoyed, flipped through it, and he read that part, rent and other amounts due. And you see a light bulb goes on, and he says, now is this, how do I know that this is another amount due? Your Honor, my client uses the UAA lease. Let's look through it. And it's very, very clear on what is owed. And it actually defines rent as all these other items that can be charged under the lease. It legally defines those as rent. And so I said, even if it didn't do that, it allows us under this other amount owed. In writing, it's very clear. This is how the security deposit was supposed to be paid. And ask her. She's not current on that. Well, but I'm current on my rent. You're out. And he threw her out. So you still want to be a little careful about that, but use a good lease that's going to help define that.
I have a lease that has tenants responsible for utilities, but I have an arrangement with the utilities that should they pay to fail to pay, that the gas stays on and automatically goes to my name, so I don't need those pipes. Is that one of the other amounts due, so if they fall behind on that, I get the bill, they're not making monthlies, and I give them an eviction notice for that?
I think it really is going to depend on the language of your lease, but I think that you're probably fine with that. I think it's going to be one of those other amounts due. If you called me with that, I would probably give you the speech if we're in that other amounts due, so there's no such thing as a slam dunk case. Anytime you're in front of a judge, there's a little bit of Las Vegas. But on that one, I think depending on the language in your lease, you're probably fine.
And I use the use our premises, is that?
You should, yes. It's got very strong language. You should be fine. And really, that situation, again, that's a 3-day pay or quit, but it's also a lease violation because they're not complying with the lease in terms of what utilities should be paid and whose name the utilities should be in. So that's one act that I think breaks up into a couple of different eviction notices that I would serve. Pay this amount that the utility company is charging me, but on top of that, 3 days to comply with the lease by putting the utilities back in your name, paying any fees that are associated with that. Take care of that. So 3-day pay or quit in action. First, you've got the rent has to be past due, so you want to check your lease. So when can you serve an eviction notice? It has to be past due. So if it's due on the 1st, don't serve an eviction notice on the 1st. It's due that day. It's not past due. Wait until the 2nd. Once they're past due, serve the 3-day pay or quit, and then they have 3 days to either pay the balance in full or quit the premises. They have to pay everything, and even if they quit, then they still owe the money. It just turns into a collection case. That happens every now and then where the tenant says, well, you told me to pay or quit, so I quit and I'm done. That doesn't work that way. They still owe the rent, and they would still owe the next month's rent if they're still under contract for that as well. So let's talk about partial payments. This is something that's really important when you're dealing with a tenant that's behind on the rent. If the tenant offers a full payment within the 3 days, Legally, you're obligated to take it. So that one client that just says, I don't care about the money, I just want them out. We give them a 3-day pay or quit and they come in with a full payment, you have to take it. It's a full payment, it's within the 3 days. But if they offer a partial payment or a payment outside of the 3 days, that's not in compliance, they haven't complied with the eviction notice, and so it gives you some options. You can either reject the payment and the eviction notice is still good, you can continue with the eviction, or you can accept the payment and it starts us all over again. It cancels out that eviction notice. And so you want to be careful. If we had a tenant that knew that rule and had the landlord's bank account, would just deposit the rent, went into the bank account, into the bank, and the deposit receipt showed this. She tried to go into court and say, I made a partial payment. And it says, cash given to the teller, $100. Amount deposited, $10. Amount refunded to the person, $90. She knows that rule, and she's just trying to screw around with it. So she went in and said, well, here's a partial payment, but don't put the whole $100 in there. But a dollar, the judge is going to think I'm too cheap, and I'd keep the $90. It didn't work. The judge was fine with continuing that eviction because we didn't accept it. And if that happens, I would immediately communicate that rejection. And that every now and then something like that happens where they mail you a check after the timeline. If you're going to reject that, I would be very clear in communicating that to them that we are rejecting this and we're going to continue with the eviction.
So what form would that rejection take?
How would you do that?
Yes, to have a record of that.
I would just, it all depends, I think, on how you've communicated with the tenants in the past. I would definitely do something in writing, and if you're ever concerned, shoot them an email and a text, or write them a letter. I mean, do whatever you think is really necessary to make the point and to give them something in writing. Because that has come up in cases every now and then, and the judge wants to know, well, what happened here? And if it's just, well, I told them, send it certified mail. If you're returning a check, send it certified mail. Now, one thing you don't want to do, though, is if they deposit it into your account, I always tell them, hey, as soon as I know that that's cleared, I'm rejecting this payment, and I will return it as soon as I know it's cleared. Because you don't want to have their check bounce or a stop payment, and then them get your check and cash it. So I would immediately communicate it, and once I verified and by the way, the court's rule on that, if they're holding funds in the court trust account, 17 business days. If you want a check cut, and I just dealt with this in a case, the tenant was making rent payments to the court for some stupid reason, and so they would put it in their trust account, and there's 17 business days. Because they said, okay, we got the payment on this date, we've settled the case, they were releasing the money to us, 17 business days, we'll cut you a check. So I would communicate it, but make sure you're not giving them a good check to combat their bad check. Oh, and real quick, my rule, let me go back. My rule is for 1 month of rent, I'll give them 3 days. Because really what you can do is, if rent is $1,000 a month, take the $1,000 and you can apply that to the balance and give them another 3-day pay or quit. If it's anything less than that, it's just up to you on what you decide. But just know that it really is, you can take the payment, give them a full credit for that, adjust the numbers, and give a new eviction notice with the current balance, giving them credit for that payment. So partial payments in action, you've got the rent past due. These income properties are supposed to be passive income, right? But when you've got a tenant that's behind on their rent making you chase you for it, it's not so much passive anymore. So you serve the 3-day pay or quit. They make a partial payment that you accept, that you're okay with, and it just loops back around. And you've got to serve a new 3-day pay or quit, starting with a new balance. How many times can you play that cat and mouse game? As many times as you like. And this is your decision. You can continue to do this, and at some point, the tenant's either going to wise up and start paying, or they're going to fall behind and they're not going to comply with the notice, and then you have them evicted. But really, either one of those, that's not too bad of a situation, because if it's only given them 3 more days, the goal is to reduce your damages so that when you file, you're filing on a lower amount of rent.
If you're charging a service and notice fee, you charge that every time they
If it's in your lease and they're past due, make sure that it's in your lease and make sure that the notice is justified. So make sure that it's past due, and yes, as long as it's in your lease and they've agreed to pay that, you should be fine. Okay, the other paper eviction notice is the no-cause lease termination. Remember, paper evictions, that's going to be the best option to be able to evict them. All it does is it provides notice that their lease isn't going to be renewed. And you can give this for any reason. It doesn't have to be for any specific reason. It just cannot be for a discriminatory reason. So you don't want to get into that. But for any other reason, you're fine to give them just a termination notice that you don't want to renew their lease. And Utah law requires that the notice be served with at least 15 days. But remember, if your lease says 30, the UAA's lease does, my lease does, most leases do. If it says a longer time period, then you want to go with the longer time frame. One thing that you want to remember, and this is something that a lot of landlords and tenants get confused on, the termination date is usually, and it depends, if you've got a weird thing in your lease, then this could be different. But 95% of the time, your lease termination date is at the end of a month. And so right now, if you gave a 15-day notice, when's the termination date? It's not 15 days from today, it's 15 days plus the end of that month. And so you go to February 29th, we're in a leap year. So it's not just a straight 15 or straight 30 calendar days notice. So if you want to terminate any leases right now, you got to hurry and get them out tomorrow or Saturday so that you're giving them the 30-day notice by February 29th. If we get a call on February 2nd or February 1st that says, man, these tenants are just driving me nuts, but it's going to be a pain to do a 3-day notice, I just want to terminate their lease. Okay, you can give them a 30-day notice, but you can't terminate it for February, so now we're March 30th. So, and then what are the chances of them paying March rent if they've got a payment butt?
So us having a student property and our lease is stating they have to give a 60-day notice to allow them, we have to give them 60 as well, correct?
So the question is if your lease says they have to give you 60 days notice, what notice do you have to give the tenant? Most of the time that's going to be reciprocal. You could in your lease specify the tenant has to give you a certain day's notice and you have to give them a different day's notice. I would be very cautious about that. I think that on something like that, I think it's best to keep it reciprocal so that you give them the same notices that they're required to give you. These are all the rest of the opinion eviction notices. And with all of these are all evictions for cause. We're the ones that bear the burden of proof. So we're the ones that have to take in the evidence and we have to prove our case. So you want to make sure you're doing everything that you can to take it from an opinion eviction and turn it into a paper eviction. So with the eviction for cause or the opinion evictions, you've got the eviction event, and in this situation, I would give the nuisance and a comply or vacate. And I would do both of those. And they have the option of either curing, and they always become the perfect angel tenants, right, as soon as you give them the eviction notice, or they have to quit. And one question that we get a lot of times, and watch this, pay attention. Did you see the angel ascend to heaven? When can you take that away? When can you say, I don't want to give you the opportunity to cure, I just want you to quit? You can cure, the tenant can cure for basic lease violations, and if it's a tenant at will. If it's something that's more substantial, and I put maybe in there because I think that I think a lot of it's going to really depend on the severity of the problems and other things it's a case-by-case basis. I can see judges deciding that differently. But if it's a more serious violation or a significant problem, then I think that you at least have the argument that you don't need to give them the opportunity to cure. It just becomes a 3-day quit notice. The example I think here is if your lease, and the UAA lease says this as well, if your lease clearly says there's no smoking and there's no pets. The problem is what happens if you find smoking pets in your property? And there's the big problem with this is if you're going to do an eviction under Utah law, you really have to catch them twice. Once, you can't give an eviction notice without a violation, right? Okay, so there's the violation. Let's give them the eviction notice. But now they have an opportunity to cure, because that's probably not a significant violation of the lease. It is to us, right? That's a big deal if you have a tenant that's doing that, if it's forbidden in your lease. But under Utah law, I've got to find a violation to say, here's your eviction notice. And then I've got to find, after the 3 days, a violation to say, here's your summons and complaint on your eviction. And that can get tricky, especially with the landlord, because if you're going to go in and do an inspection to find out if they really got rid of their 17 cats, you have to give their a 24-hour notice. And when you're doing an eviction, a 24-hour notice is a 23.5-hour notice to go hide your cats. So it becomes a problem. And you can use, I think the best way to solve this is in your lease. Use your lease to help define what's curable and what's not. And use your lease to define when you can go in and when you cannot. And so those two things I think are really helpful. In our lease, what I put in there, and by the way, the UAA lease, Taylor, are you going to be offended if I say that our lease is tied for first place?
That's fair.
Okay. The UAA lease is great as well. So if you're using the UAA lease, I have zero problems because it's very strong as well. The language I have in mind is smoking and pets are violations of the lease that cannot be brought back into compliance and subject the tenant to an immediate 3-day eviction. And so that way I've defined and they've agreed to what is curable and what is not. So that's something I think that can help with an eviction.
Question. The slide before this, you had unlawful business.
A little ways back.
The slide just before this one. On cannot cure unlawful business. I wondered what that would be.
If they're operating a business out of the home when they shouldn't be, or if there's a business that's bringing illegal activity.
So car repairs in the backyard.
So yeah, car repairs in the backyard if it's not if it's on a residential property.
Daycare.
Yeah, daycare.
Okay.
That could be one. Okay, so types of nuisances. Under Utah law, there are 2 types of nuisances, and they make the distinction because, basically because of severity. But with the definition with the nuisances, basically they're being a pain in the butt. But as an attorney, as a legislator, you can't write that in the code. So they are interfering with the comfortable enjoyment of life or property. That's what a nuisance is. And I think that definition is fine because it helps to keep a good broad range of anything that is causing somebody to be a pain in the neck. Nuisance evictions can be difficult though because you want to, a judge isn't going to issue an eviction on a nuisance unless it's a significant breach of the interference of quiet enjoyment of the property. So you want to be careful there. And you want to make sure you're documenting your case. If you have other neighbors or other tenants, if it's a duplex and the other side keeps calling, one of the biggest problems that you have is proving that. And so I tell them, hey, you don't have to give them the exact speech, but I went to this attorney and he told me about paper evictions and opinion evictions. I want you to help turn this into a paper eviction. I want you to start tracking it. And once it gets bad enough to where you're comfortable with it, then we can move forward. And also tell them, by the way, I'm going to need you to come to court. So I can't go in and prove this myself because all this stuff you're telling me, that's called hearsay. And as soon as I say, well, the other tenant or the other neighbors, or here's an affidavit, a sworn statement from the neighbors that says they're a nuisance, they have to be in court so that they can be cross-examined for it to be evidence that we can put in front of the judge. The 2 types of nuisance evictions are criminal nuisance and then a non-criminal nuisance. And they make that difference because, and we'll talk about it in a few minutes, but a criminal nuisance, they take that a little bit more seriously. There are expedited procedures that help to speed up the eviction so that you can work through that a little bit faster than a regular nuisance. And by the way, under Utah law, smoking that drifts into another unit, that can be a lease violation and it can be a nuisance, but you have to prohibit smoking in your entire unit. And if you have any questions about nuisance notices, you'll definitely want to call us because they can be tricky. You want to make sure that you've got a good, strong case because judges look at those a little bit closer because a lot of it is he said, she said, with our word against theirs. Assigning or subletting, if they've let somebody else in their property, first and foremost, it has to be a violation of the lease. So you can have a verbal contract, but then you need to show that they verbally agreed that they wouldn't assign or sublet or let anybody else in, and that can be a problem. So just have it clear in your lease, and the UAA lease is great on this. Don't assign or sublet. And it requires them to vacate within the 3 calendar days. One thing that's interesting about assigning or subletting, what happens, and we're dealing with this on a case right now, the tenant moved out, and they're not living there anymore, and they've moved other people in. The statute specifically says that somebody is guilty of unlawful detainer and subject to eviction if they or their subtenants have remained in the property. So even though they've left, they're still guilty of unlawful detainer. They still can get an eviction order against them, even though they're not there. And they can still get a judgment with treble damages and the whole 9 yards because they are on the lease and they have sublet and let somebody else in that's not leaving now.
Do you have to go find them if they've left the property?
So the question is, do you have to go find them if they've left the property? They have to be served the notices, and so we'll talk about serving eviction notices, and on this case, we serve the summons complaint directly to the person. So yes, they do have to get notice of it. Just follow the statutes to make sure that that's happening. So the waste, and this, we talked about this for a minute. This waste is damage to the property. And the example here is what happens if you have a tenant, cleaning car parts in the middle of winter outside. It's just cold, right? So the obvious thing to do is bring them inside. But that makes your apartment really smelly. And what do you do to get rid of smells? Well, you light a scented candle, of course.
Yeah.
And I don't know if you can see it in your handout real well, but luckily it was just a little bit of gasoline in the bottom of a little bucket. And it was mainly the fumes that ignited and scorched everything. I have another picture where they opened the dishwasher, and it looked like, is it stalactites or stalagmites that come from the ceiling? Stalactites. It was just melted and dripped. The plastic was just dripping down in the dishwasher. And so these people got a 3-day eviction notice for committing waste to the property. It wasn't habitable anyway, so they voluntarily left. But now it was a collection case. We filed the case, got the damages, and then we can collect on that. And by the way, with the damages, you guys know this, you are responsible for normal wear and tear. The tenant is responsible for waste. There's a broad spectrum in the middle that's gray area. And so my approach is to be reasonable. As landlords, you understand that these properties need repairs and updates and things. But there's a middle area where the tenants shouldn't be abusing that either. And so that's a common factual issue that judges have to decide of what's reasonable wear and tear or what's damage to the property. This is one that I think is important. A tenant at will is someone that does not have any right to occupy the property. And so we get a lot of clients that call in and say, well, I don't have a lease with them, and so I gave them a 5-day tenant at will. And the questions, here are the examples of what a tenant at will is. If they've moved a friend in, if a guest establishes residency there, your lease terminates and it doesn't go month to month and they've stuck around, then they don't have any legal right to be there. Or if you're an investor, you purchase the property at a foreclosure sale, that foreclosure sale wipes out their rights to occupy the property. Now they're a tenant at will. So those are the more common situations of where a tenant at will. For me, if you're trying to figure out if somebody's a tenant at will, I ask clients 2 questions. Number 1, how long have they been there? And number 2, have you accepted any rent? Because there's a lot of times somebody says, well, we don't have a lease with them, they're a tenant at will, and I gave them the notice and they won't leave. How long have they been there? Well, it's the mom's on the lease, but it's the son, and he moved in about 4 months ago. Okay? And have they been paying rent since then? Yeah, he comes over and he'll pay the rent, but I just want him out. Okay? What you have is probably a verbal lease with that person. And under Utah law, a verbal lease is just as enforceable as a written lease. The problem is it's a pain in the butt to figure out what is agreed to in an oral lease. If it's a written lease, it's obvious. Look at the lease. Paragraph 382 says this. That's what your lease is. If it's a verbal lease in that situation, it's just always, it can be a huge fight to figure out what everybody agreed to. So it can be a problem.
Jeremy, what if you, I've seen extra cars at one of my places, but I've never seen any people.
So the question,
the
question is if you see extra cars at your place, and they've been there for a while, but you're not really seeing any people. That's something where I'd probably pay a little bit more attention if it's a duplex and you can ask the neighbors to help. You want to be careful because they might be friends, but I would just watch that. And at some point, hopefully there's a tipping point because the judge is going to be looking at the same thing. If we take that case to court, the judge is going to say, what proof do you have that they've assigned and sublet the property, that these people are tenants at will, that they're actually residing there? Because you and I both know, as soon as you approach them about it, Oh, no, they don't live here. It's just a buddy of mine, and he just needed a place to crash because he just got evicted. But it happens. And so you just need to help document your case, build up some evidence, because if it happens once, the tipping point with the judge is typically 51%. Luckily, it's a civil case, so we don't have the beyond a reasonable doubt standard. But we've got to prove that it's more likely than not that they are violating the lease, that they're doing this. And so you want to get as much evidence as you can. And if we can get 51%, we win. If we can get 99%, we're going to win. But just where's that tipping point? It's up to the judge. There's a judge here in West Jordan. He's a great judge. And every now and then I'll try to feel him out of, have we given you enough yet? Are we at 51%? And bless his heart, he won't give me any indication. And so I'm like, oh, sorry, I'll waste some more time and parade in the second police officer that saw what happened and go through the process that way. So there's a tipping point, 51%, but don't file an eviction if you've got 51%. Try to get 60, 70, 80% so that you've got a little bit of wiggle room. So.
I have a question. If the person that's on the lease is either arrested or incarcerated by somehow, if there are people living in that apartment, if they had people staying at the apartment, now are they considered tenants too? I mean, what's your right?
Were they also on the lease?
No, they weren't on the lease.
So the question is, if you've got
the leasee was arrested and ended up serving some time in jail, but there were people still left in the apartment.
Friends, or who are they?
They must have been friends of theirs.
So the question is, if you have a tenant that's arrested and incarcerated and there are other people there, I'd still go back to those two questions. How long have you known that they've been there? And you know what? If they've been there for 6 months, but you just found out 6 hours ago, I think that you're probably okay calling them a tenant at will. So it really depends on the circumstances, but in that situation where the tenant is now gone and you have people in your property that don't have any legal right to be there, and you haven't given them any legal right through waiver, if you've waited so long that there's an implied contract that now they can say that the landlord knew I was here and he didn't do anything about it, you just want to be careful of that situation. So if you act quickly in that situation, you should be okay.
A number of days that you have to give them? Can you classify them as squatters or something? I mean,
with a lot of things in the law, the question is, at what point can you? Is there a certain number of days that you have to watch for? And no, there's not. Under Utah law, with a lot of things, there's some gray area where I think it's just going to depend on the circumstances. That's where I think that you need to be diligent in documenting. And if you send them a letter, I just found out yesterday that you're living there. You're not on the lease. I'm happy to take a rental application, but in the meantime, here's a 5-day notice to a tenant at will. That'll give us some time to get a rental application to figure out if we're going to enter a lease. But right now, there is not a lease in place, and you either need to figure this out or you need to be out in 5 days. So serving. Go ahead.
What if you don't know who they are? How do you get served with somebody you don't know who they are?
That's a tricky one. What if you don't know who they are? That's a tricky one.
Could you classify them as trespassing at all? I mean, if they're not on lease,
do you call the cops and have them come and try to move them out of the apartment? I mean, where's your legal?
Can you call the cops? Absolutely. Are they going to do anything about it? Probably absolutely not. Because their famous saying, and if you guys have called the police in that type of a situation, I'll bet you've heard this saying, that sounds like a civil matter to me. That's what they say, because they don't want to get involved. And so they're actually looking at making a change to the law to kind of help clarify some of that, and hopefully the police will help get involved. Because there's sometimes where they're obvious squatters and the police still won't get involved. I just had a case that happened and the police got involved. It sounds like a civil matter to me, so we filed the case and there was an assault. That's why the police showed up. And when we got into court, there were 2 police officers that came into court with us, and when I called them to come, I said, you were there and the tenant admitted to macing the tow truck driver that showed up to tow his car. And the tenant admitted 3 times to macing the tow truck driver. So I said, police officers, I need you both there. And they said, well, we can't. It's a civil matter. I said, officer, you're a witness in a civil matter. I need you there. I can issue you a subpoena, and I happen to know that I'll bet you're going to get time and a half because you're doing this, because it's not a regular shift. And it took a little bit of talking, but even in that situation, I kind of had to butter up the police officers to get them on board with what we were doing. And so if I have to twist an arm a little bit nicely, and they were great to deal with, but if I have to treat that carefully, it's going to be really hard for you guys to convince the police to throw somebody out on the street. When I'm going, it's a civil matter, you're right. And we did exactly what you always tell people to do because you don't want to put it in your paperwork and deal with it. You pass the buck all the time, and now we did that, and I need you to come and be a witness. And once they understood it, they were fine to come, and they were great.
As we realize, this is all income property, so we make income on this stuff. So a lot of times when you decide to evict somebody, sometimes you have to worry, are they going to be worse, the new ones I bring in? Are we going to have the same problems? So the best thing to do is do the best you can, whatever it is. But when you get the police involved, they're not going to like you too well. When you get other things going and you start ripping on them, they're going to start doing bad things to your property.
Yeah.
So it's a tight one.
Yeah, you want to be careful because if you threaten eviction, if you try to get, you play the bad cop card with them, there's a concern that they're going to damage the property. Sign up for our newsletter because that's actually one of the things I'm going to talk about next month. That's one of the questions that we get is, I don't want to evict them because I'm just going to provoke them to cause problems and damage the property. And I think that's a fallacy. I don't think that's true. Because I think if they're going to damage it, I think that they're less likely to damage it if they know an eviction attorney and a judge is overseeing what's going on. So, and if I evict them in 2 to 3 weeks and you try to work with them for 2 to 3 months, they've got less opportunity to damage the property as well. So serving eviction notices, under Utah law, there are 4 options. You can serve it personally by hand delivering a copy to them. You can substitute service by giving it to a person of suitable age and discretion, and that's typically somebody 14 or above. You can post it on the property, so and that happens. We get this question every now and then. I can just go up and post it and run off, right? The statute says if a person of suitable age and discretion cannot be found, then you post it in a conspicuous place on the property. So you do need to attempt to knock. I don't think you need to knock 4 or 5 times and wait, ring the doorbell a bunch, but you do need to attempt to find somebody. A lot of times what clients will do is post it and then knock. And if they answer, then it's already there. If they don't answer, then it's fine. But I know that can be a little nerve-wracking. I was here today doing some training, and I was reminded of a story. We had a client that went to serve the eviction notice, and it was a post-foreclosure eviction, and those can be a little crazy sometimes. And so he wanted to document that he was serving it. And so he had, I guess he's a skier or something, and he had a chest mount GoPro. And so he went up and served the eviction notice with his GoPro on his chest, making sure that it was taking good pictures. But as we were watching it, we were kind of chuckling in the office. As we were watching it, all of a sudden I heard something, and then I turned up the sound, and you could hear thump, 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 thump. He was nervous going up and posted on the door. So the 4th option is to mail it via certified or registered mail. Certified mail is cheaper, so just do that one. But if you ask me, please don't serve it by certified mail. Don't mail it off, because the question is when does that 3 days start? If you can go up to the house and knock and hand it to somebody or post it on the door and it's served that day, then don't waste time mailing it off. Because what happens if they never sign for it? If they owe a bunch of people money and they get a registered letter from the post office, the chances of them going in and signing for it is slim to none. So I would, if it were me personally, I would just take it out. There are 4 ways under Utah law, but go with those 3. I think those are the 3 best options. A couple of things, go ahead.
And if you post it in a conspicuous place, it does not need to be in an envelope.
That's a good question, yeah. If you post it in a conspicuous place, I would not put it in an envelope because that gives them an argument that it wasn't in a conspicuous place. Every now and then I'll get a landlord that says, yeah, I like my tenants, I didn't want to embarrass them, and so I put it in an envelope underneath a mat and I texted them and said it's there. That's not a conspicuous place. If that were me, just if you don't want to embarrass them, text them and tell them I'm coming over and to give you a notice, I'd like to talk to you about it, and try to get them there. Or post it and text them immediately and say, I just want to let you know that it's there, if that's what you're concerned about. But I would not put it in an envelope and shove it under the doormat. So who can serve an eviction notice? Anyone that's 18 or older. There's other court papers that have restrictions where you can't serve those, but on an eviction notice, a landlord can do that. Anybody can do that as long as they're 18 or older. For my suggestion with serving notices, the best practice for me is to not post and picture. So attempt personal service. If they don't answer, post it and take a picture with your phone. And you can't email it. I've emailed eviction notices as a secondary matter. If I don't think that they're going to get it, I have to serve the property, I'll serve it. I'll also email it to them just to say, hey, this is here. We had one where we don't have time for it, but anyway, you can email it as a practical side to help them get it, but legally you're not complying with the statute. So only do that as a secondary matter to get them notice of what's happening. Why should you not post and picture? And this is a real case that we dealt with, we went to court on. My office literally closed down because everybody wanted to go see the judge on this one. Because when you post the notice on top of the Halloween decorations like this, and these are 2 pictures from my client, you'll walk into court and your tenants will give the judge a picture that looks exactly like this. And you can't really even see it, but there's the eviction notice. They put it behind the Halloween decorations. And the interesting thing is, and you want to look at this, the beautiful thing was this tenant hired an attorney and sent this over and said, oh, this is improper notice. You don't have any case. He didn't know I had these 2. So we got to go into court and he blabbed about his picture and I had 2 pictures that were even better. But a couple of things about this. My client taped all 4 corners and she was there prepared to testify that that's her standard practice and procedure. I always do that. And theirs, you can't see it on the flyer there, but they only did 1 piece of tape up at the top. That wasn't her posting job. Also, there's wrinkles everywhere on their version because they ripped theirs off, wadded it up, and then said, hey, I've got an idea. Let's do a Photoshop version and put it back up. It's missing a green eye on their copy that was because they ripped it off and put it back on. And then that, on the right side, that black line, that's actually the door frame, the weather stripping. So the door's open. If you close that, it's actually shoved in the door frame. So they did a horrible job. And this was so beautiful. The judge didn't even make me call any witnesses, didn't ask any other questions, and just said, you're out. So it worked out really, really well. Filing the case with the court was step 2. When can you file? Only after an eviction notice has expired. And so if you do that, we talked a minute ago about serving 3-day notices and a 30-day notice. You can file after the 3-day notices, but it's only going to be for those 3-day notices. So you can do that. Or if you can be patient, you can wait until that 15 or 30-day notice is up. Whenever you file, it's focused on the eviction notices that were expired at the time of filing.
Can you do both at the same time?
What do you mean?
The 3-day and the eviction?
Yeah, you can serve both notices at the same time, and then whenever you file, I mean, we had, 8 or 9 eviction notices? If all of those have expired, if you served all of those, that would be a horrible tenant. And then all of them have expired and we file a case, then I'll attach 9 different exhibits that show 9 different grounds for eviction. And then I only have to prove one of them, but I've got 9 bites of the apple. So yes, you can do that. Couple of reasons that you might want to consider an attorney. Number 1 is speed. We're about 2 to 3 weeks. For example, when you file a regular lawsuit, normally defendants have 21 days to respond. In an eviction, the statute says if the judge or the plaintiff's attorney signs off on the summons, you can automatically reduce that down to 3 business days. So that alone cuts off some time. The other thing is the e-filing system, instant communication with the court, that helps as well. And a lot of times, it really is a savings opportunity because if we can get them out in 2 to 3 weeks and it's going to take you 2 to 3 months, what's your monthly rent? Because however fast I can get them out, if you take longer, if you take an extra month, that's a month of rent that I'm saving by getting them out faster. And then the convenience, obviously. I can change my own oil. I don't do it though. So And legally, you may need to use an attorney. If you have an LLC, you can represent yourself in court, but the reason you set up an LLC is because now that's separate from you personally, and in that situation, you can't represent your LLC because you're not an attorney. You need to get an attorney for that. Treble damages. This is something that I think is unique to Utah, and it's an important issue as you're looking at evictions. Under the code, the judge shall award treble damages. And there's a few different ways to handle that, but for me the big thing is the winner gets to triple certain charges. And so you want to make sure you're the winner. Don't cut corners, don't do anything that's shady. Make sure that you are on the right end of that. We had one a while ago. A landlord called us and said, I just got sued, can you help me? Well, what happened? And they bullied their tenant out, got them out, and put their stuff out on the lawn, and it rained. And they said, they're saying that stuff was worth $30,000. There's no way it was. I said, well, maybe not, but let's say that it's $20,000 or $15,000. And I told him, I said, so you just got sued for 90 grand, didn't you? Yeah, because 30,000 times 3 is 90,000 bucks. And I told her, I said, you probably ought to settle that one quick, because you're on the losing end of that one. Eviction hearings, and this is only if the case is disputed. If they don't fight it, then you don't have to go to a hearing. But under Utah law, they have to hold a trial within 60 days on an eviction. But when you can do an eviction in 2 to 3 weeks, there's a couple of options for being able to expedite it. There's really 4 different cases where you can get an expedited eviction. Number 1 is for non-payment of rents. Thank goodness, because that's the most common type of eviction, and that's usually the one where you need the quickest amount of help, right? If these were allowed to go on for months and months, now that puts you in a bind where there's a potential foreclosure issue as well. So you automatically get that expedited eviction. Criminal nuisance is the second option. Post-foreclosure eviction, so if you're an investor that buys it on the courthouse steps, you've got a tenant at will, you're entitled to an emergency eviction hearing. And then the fourth one is a possession bond. If you don't fit into one of the first 3 options, you can post a possession bond. It's basically a security deposit that the landlord pays to the court to say, I'm serious about this eviction and I want to expedite it. And so it can help to speed things up. It puts that bond at risk, so you want to make sure that you're in a good, strong case. But in certain circumstances, the tenant might have to post a bond. And we had one case where we said the rent that's owed is $1,500. But or the 2 months of rent that typically what a bond is $1,500. But they owe us $1,000. We got our bond set at $500, and then we started adding theirs up, and we got their bond at $8,000. And they posted it, idiots. And we went to trial. One got a $31,000 judgment with the treble damages, and there was $8,000 sitting down at the front desk with the clerks in their bond that we collected on. Then we garnished and started collecting on the rest of it as well. So, okay, final test. And by the way, this is literally what happened to me in law school, this situation. I was living next to Druggy Dan. So Druggy Dan signed a year-long lease 15 months ago, and he's been a problem ever since. The neighbors are constantly complaining about Dan using drugs. You found a police report that Dan was arrested down the street for meth. Dan also had his girlfriend, Martha Methhead, move in with him without receiving your permission. So that's the situation that you're dealing with. What eviction notices should you give? Tenant at will. Didn't say anything about being late on the rent. Nuisance. Subletting. Criminal acts on the property. Oh, thank you. No cause. The paper eviction. Put that one first. And that's what I did. Literally, I'm serious. That's exactly what happened to me. I saw midnight one night. I was watching TV and I could hear footsteps coming up the stairs and the doors faced each other. And I was worried about it. And so I went out to the people and watched a drug transaction. The door opened 6 inches. There was an exchange of goods. And the guy turned to leave and didn't like his exchange of goods and went back and pounded on the door. They got in an argument, and a fight, and a wrestling match. And then they realized they were being too loud, and so they very quickly scattered off and they were done. That's a drug deal. And so I went to the management and I said, either they're leaving or I'm leaving. Would you rather have me or a drug dealer? You pick. And they said, they did what they should have. Well, okay, that's a criminal act, that's a nuisance, you don't feel comfortable here, so we're going to need you to go to court. And I said, absolutely not. But they're on a month-to-month, right? I can wait patiently for 30 days, just give them that 30-day notice. And so in that situation, they just gave the 30-day notice and it was fine. But with Dan, and this is something you need to realize as well, Dan's eviction notices might be different from Martha's, right? Because you can't give Martha a lease violation eviction notice. She's not on the lease. She is a tenant at will, and she's been assigned or subletting the property. So I would do both of those for Martha. And then for Dan, I think we listed all those in our discussion. But I would start with that no-cause notice. Terminate the lease and just ask her to leave. If you end up having to file for eviction, who are the defendants? The answer is really whoever you listed on your eviction notices. And that's where it's helpful that our notices, the UAA's notices, give you a spot to fill in, and that says, and all other tenants known. Try not to rely on that, and all other tenants known. Try to list people, but there are certain circumstances where you might not know their names. So that's as a catch-all, but I wouldn't rely on that very often. I'd list people if you can. If you change that scenario, and Dan is only 6 months into his 12-month lease, what do? Basically the exact same thing. Take out the no-cause notice. That's not an option. You could give it now and say, hey, we're terminating your lease in 6 months. But I would do all the other notices and build your case. Try to take it from an opinion eviction and build it up so that it's a paper eviction so that you're as strong as possible with that. So,
Realizing that sometimes it's easy just to say, when do you ever offer cash for keys? At what point in the negotiations and eviction process, pre-report, after-report, do you say, I'll give you $500 just
yeah, the question is, so when do you use cash for keys? It's a case-by-case basis. But I think that you need to realize that in Utah, evictions are not that expensive. They're hundreds of dollars, typically on average. And so, and if they're saying, okay, you pay me $1,000 and I'll be out in 30 days, I'll charge less than that on average, and I'm going to get them out faster than that on average. So it's case-by-case basis, but be careful and know in the back of your mind, if you've got a good, strong eviction case, I wouldn't negotiate them for a worse deal, because if it's going to cost less and get them out faster to evict them, and you can get a judgment that we can try to collect on, then it can be, you might not want to do that.
I did once a cash for key, but only because I feel tenants provoke them to, damage your drywall, plug your kitchen.
And cash for keys has a good spot. Can I switch that though? Call it keys for cash. Get the keys first, and then you give them the money. But there's a viable, practical solution that can come up before the legal solution of an eviction.
What if you have a tenant that files bankruptcy?
Good question. So a tenant that files bankruptcy, it's going to depend on, under the bankruptcy laws, it's a race. What happens first? Two things. An eviction order or they're filing bankruptcy. Whichever happens first takes precedent. And we had this happen on a case a little while ago. It happens every now and then, but we went through, they served the notice, we filed the eviction, they didn't respond, we got the eviction order and the judgment, and then that's when they decided, you know what, honey, we've been talking about bankruptcy, I don't want to get evicted, let's go file. And so then they finally made the appointment with the attorney and they filed the bankruptcy. And this is something where the bankruptcy attorney didn't even know this. They sent over the notice of bankruptcy and said, stop, there's an automatic stay, you can't evict us. And I wrote back, and this is a bankruptcy law firm. They've got multiple attorneys and that's all they do. And I wrote back and said, I've received your notice of bankruptcy, thank you. All the financial issues will be handled in the bankruptcy court, which we're going to get pennies on the dollar or nothing. And all of the possession issues of the eviction have already been determined, and so your client needs to be out on Thursday. The sheriff is showing up Friday. And they sent the notice to me with a couple of other attorneys in their office copied on it. And I hit reply to all just so they all knew. And I don't know if it was on purpose or accident, but somebody in their office hit reply to all. And I was on the email. And it basically said, I should get a screenshot of it. Can you believe this twit? Tell me if you want me to get sanctions against him. I'd be happy to take him to town. And so I wrote back, and I was polite. That's the best way. When somebody's being a jerk, be polite to them. They don't know. They're expecting the jerk back. So I wrote back and just said, I don't know if I was intended to be on that, but I just wanted to clarify. And I just copied and pasted. The financial matters are in the bankruptcy. Possession has already been determined. You need to be out Thursday. And then he really started getting nasty with me. And I finally just said, why don't you read this? And I gave him the citation once I let him run his mouth off for a little bit. And the only thing he had to say after that was, well, ethically, I don't know how you can do that. Ethically, you don't know how an attorney can follow the law? Okay, well, we're going to do it. Ethics or not, that's what the law says, and we're going to do it. Friday morning, the sheriff's coming out, and I'm sure they had egg on their face, because I'm sure that they told their... It's a very common sales practice in a bankruptcy. All this financial pressure that you're feeling, are you being garnished? We can stop all of that. You're being evicted, I can stop that. But they misread that law, and when he figured it out, he had a very awkward conversation with his client that they were wrong.
So what if it's the opposite? What if they filed and then you bring one?
Then you find out.
Good question. What that does, as soon as somebody files bankruptcy, there's an automatic stay in place for any legal action. And so that 2 to 3 week process, if they file bankruptcy before the eviction order, that turns it into a 2 to 3 month process. That takes, it takes a significant amount of time, because what you have to do, those 3 steps that we're talking about, wherever you are in that process, if it's the day before the eviction hearing, all of that's on hold. As soon as they file bankruptcy, it's all paused, it's an automatic stay. And now we have to go to the bankruptcy court and say, we would like your permission to continue this eviction. And that takes 2 to 3 months to go through, start to finish, because we've got to, it's about 6 weeks or so to go to the bankruptcy court, but then you need to add on that 2 to 3 weeks to get through the regular eviction process.
Our tenant came the day of court. She filed while we were at court.
Yeah, it can be a pain. So. That's everything. Congratulations, you graduated from the Utah Eviction Law School of Hard Knocks. A lot of times as a landlord, that's what it is. Experience means so much, and that's where I think that the UAA is extremely valuable. Getting to know other landlords and getting to hear these war stories and getting to use good forms, that really helps to improve yourselves as landlords. And so I'd encourage you to take advantage. I'm glad to see so many people here, but I tell you to take advantage of all the different programs and different things that the UAA has to offer. They run me out of business, Taylor.
Good classes, though.
Yeah. Say that again. Oh, yeah. Yeah, possession bond. What was the question with it? What is it?
Right.
Yeah, that's the 4 different ways to get an expedited eviction. If you're not 3-day pay or quit, if you're not a criminal nuisance, if you're not post foreclosure, and you still want an expedited eviction, you can post a possession bond with the court. Typically it's 2 months of rent, because the trial has to be held within 60 days. So they say post a bond that covers that 60-day time frame, and then we'll put you on that expedited track. So that's what that possession bond is. And the tenant, like I was saying, in some circumstances has to post a counter bond. The nice thing is the statute, I gave you the example of it, but the statute uses different standards. Under the bond, the landlord pays, the tenant's potential damages, which is typically that 60 days rent. Under the tenant's bond, it's potential damages, which the landlord's at a much higher risk, plus attorney's fees and costs. And that's how we got that bond up to $8,000 on that case. If you have other questions, I'll stick around, but that's everything. Thank you for coming. Good job.